all to the fifth webinar session of the webinar series being organized by the Delhi University Faculty of Law Alumni Association. Today's speaker requires no introduction. He is one of the most respected members of the fraternity, a tall leader, a noted criminal lawyer, and a champion of rights of the advocates, especially the young members. Let us all welcome Shri Mohit Mathur, Senior Advocate and President of the Delhi High Court Bar Association, who has graciously accepted to address on this seminar on the topic of law of bails under special laws. Before we proceed any further, allow me to speak of the glorious journey of our esteemed speaker. Mr. Mohit Mathur belongs from a family of noted jurists and lawyers, a third generation lawyer himself. He is the son of Shri D.C. Mathur, senior advocate, and grandson of late Shri Tarachand Mathur, the legendary criminal lawyer. Mr. Mathur did his schooling from St. Xavier's, Delhi, and thereafter graduated from St. Stephen's, the University of Delhi. He graduated in law in the year 1991 from the Faculty of Law, Delhi University, and joined the chambers of then Attorney General of India, Shri G. Ramaswamy. Mr. Mathur, for the past 29 years, has proficiently handled cases in various fields at the Supreme Court of India and various high courts in India. He has practiced extensively in the criminal law fields such as the Prevention of Corruption Act, Food Safety Act, and economic offences. He has been associated with a number of high-profile and prominent cases such as the Jain Dairy Hawala case, Beaufort's case, coal allocation corruption trial and appeals, and JMM and MP's bribery case, besides other several cases. I, on behalf of Delhi University Faculty of Law Alumni Association, welcome Shri Mohit Mathur and request him to kindly come on the screen and address this webinar. Thank you.
Thank you, Gurpreet. Thank you, all of you of DUFLA who have invited me to speak on law of bails in special statutes, which today occupy a large portion of the cases which keep coming to the courts. I must thank at the outset the Delhi University Faculty of Law Association, DUFLA, Manish, Tiwari, Shubham, who has tirelessly worked to get me understand this computer systems, Karthik, Sohail, Aditya, Mayank, and Mr. Rakesh Sharma, and my dear esteemed colleague in my executive committee, Amit Saxena, who's like a younger brother to me, who insisted that I should speak on this subject for the benefit of the younger members who keep facing and encountering difficulties with the bench when they want to push for their bail applications. If I may presume for a moment, if I may be permitted to presume, all of us understand the basic concept of bails as per the Criminal Procedure Code. But special statutes somehow, in many of them, deviate from the general law, which is provided for the Indian Penal Code under the CRPC. Now, whether an offense is a bailable or a non-bailable one, also either is governed by the second schedule, the classification to the CRPC, or the act itself, whichever is the special law, would try and govern the aspect of bail as far as the accused against whom those sections have been invoked. Now, our criminal justice system has created a scheme where an accused may be accused who is charged of the offense under those special statutes, may be legally detained, sometimes remanded, and at other times they may be arrested and released on bail, being bailable offenses. We also need to understand that the once a special law has within its compass also covered the provisions of bail, or whenever the special law provides for certain restrictions on the release of the person on bail, then those have to be honored, being special statutes where the special statute prevails over the general law as such. Chapter 33 under the CRPC, which governs the bails, starts from section 436, which is for bailable offences. Now, a bail application in cases where the offences are bailable are generally moved as a simpliciter application, because there are certain statutes like minor acts and even acts like the Income Tax Act or other statutes of Wildlife Act and all, where many a time the complaints are filed without any arrest. Then the principle which governs this would be that a person who has not been arrested on the time when the investigating agencies or the prosecuting agencies are covering the case or interrogating the people, collecting material, at that time, if they have not arrested, then those people are generally released, either because they are bailable offences or otherwise because during the course of investigation and interrogation, they have not been arrested. However, one difficulty which people, all of you would have encountered in this period is the fact that many statutes today have tried to bring in certain embargoes on the release of the person on bail by either adding conditions or many times the provisions of section 438, that's the what we generally commonly understand as anticipatory bail, are totally done away with. In certain statutes, the Supreme Court had allowed the taking away of the liberty by deleting of section 438 by virtue of the provisions within the special statutes itself. One such statute which comes to mind and would be of general applicability, and most of you would have probably had a chance to deal with, is the Scheduled Caste and Scheduled Tribes Prevention of Atrocities Act. Section 18 in that statute clearly bars the applicability of section 438, or one would say anticipatory bails. Bail order in anticipation or apprehending arrest is generally been recognized as a right to our liberty under Article 21. But by due process of law, it can be taken away. On that basis, the provision of section 18 has been upheld by the Supreme Court. However, the Supreme Court also holds in a number of judgments, and the high courts have followed suit in several their own judgments, as well as following the Supreme Court judgment as well, that the anticipatory bail may not be granted if in case a prima facie case is made out under the SC and ST Act. However, if in case the provisions of the Act or the ingredients of the offence are not attracted, then in that scenario, the courts do not shun the accused, and they have proactively even permitted bails to be granted by way of a protective order. Now, those orders are generally passed in terms of the High Court's plenary powers under the writ jurisdiction, and sometimes even under Section 482. They permit the accused to be let loose, left at liberty, so that he can safeguard his interest and his rights. So one must understand that bail has to be equated with your right to life and liberty. and your liberty is somehow to be protected. And therefore, in case the statute does not provide or creates an embargo, then there are other ways in which you have to approach the court for the necessary relief and the remedy. Of late, one would find there are a number of statutes where a condition which was originally brought in the very, very serious cases of terrorist and unlawful activities, where what we commonly use as term as a twin condition, where the person could not be released on bail without, first condition, affording an opportunity to the prosecutor to oppose it. And secondly, another condition which was felt onerous at times was that he will not be released on bail unless and until there is a reasonable ground that he is not guilty of the offense which is alleged. Now, this second condition, the first condition obviously was only to afford an opportunity to the prosecution, which as a part of fair play is permissible. But the second condition, which actually creates that burden or makes it tedious, is somehow going across and traversing this condition of reasonable, trying to satisfy the court of reasonable ground that you are not guilty of the offense alleged. Over time, now this conditions initially came in the TADA, then in the Narcotic Drugs and Psychotropic Substances Act of 1985, NDPS Act as we commonly call. And it started following somehow in all the other statutes as well, where, in my humble opinion, mostly it is the economic impact and not a very serious or heinous impact on the society as such. It was not a case of drugs or the terrorism, which was and has been treated as very, very serious offense, not just in the nation, but in India, but universally, globally, they have an impact. And therefore, the liberty should not be so easily granted to the person who is accused of such an offense. On that basis, these conditions were put. However, what has happened of late is that we find that the bail applications have to be filed in cases which basically have an economic impact, like a law which has been incorporated only about 15 years back. That's the Prevention of Money Laundering Act. And then about 5 years back came the amendment in the 5-6 years back in the Companies Act, in which Section 212 was incorporated, and that brought in 2016-17 the power of arrest was brought in, and then the twin conditions of whether to release the person on bail. You have to basically overhaul these twin conditions and the twin test. Whenever we are dealing with bails under these statutes, we must know and understand as a counsel, first, what is the allegation? Second, we must also break into parts our act, how and whether it falls under these statutes or not. And thirdly, is to somehow scale the wall of these stringent conditions. Earlier, economic offenses were basically limited to the customs and excise and FERA laws, which when we started our profession were considered those serious economic offenses, and the courts used to look at those things as smuggling being a very, very serious offense, as it hit the economy, and all those kind of phrases were used. But however, the bail still would be granted because there were no conditions as such which the court had to overcome or the accused had to overcome before it could seek bail. But in the recent statutes like the Prevention of Money Laundering Act or in the Prevention of Corruption Act, these conditions are not there, twin conditions are not there, but then Corruption Act has been made much more stringent by increasing the sentence. So the severity of the sentence has been increased, the gravity changes of the offense. And now with the Companies Act, the SFIO has been created, a Serious Fraud Investigating Office has been created. And today it's become a routine to haul people up, arrest them, keep them in custody, go right up to the Supreme Court to not allow them to be free. Now, this is the area where we as counsels have to understand, appreciate, and then make our strategies. Please bear in mind, you are not seeking an acquittal, and that is not the test at the time of bail. This, as far as the PMLA is concerned, I am leaving it for the time being, because there is a judgment which I am sure all of us must be aware, that's of Nikesh Tarachand Shah, where the Supreme Court struck down these two conditions, saying that they are violative of the Article 21 and the general law of Section 438, 439 rules, the principles governing 438 and 439 would prevail. And by virtue of that, in PMLA, the bails have the effort has become a little easier, and it's not as stiff as it used to be with those twin conditions. But keeping that aside, if we take the other statute, wherever these conditions are there, then please bear in mind that the second condition of satisfying the test of reasonable grounds to believe that the person is not guilty of the offense, this not guilty here is not seeking an acquittal. Right from Ranif's judgment and other judgments of the Supreme Court, the court has said this test is only of a prima facie. You have to prima facie show you have an arguable case. You are not seeking and thrashing out on the merits, and you're not seeking an acquittal at this, because if we take it to an absurd extent, then taking this to its logical conclusion, we end up in an absurdity, and that is the person will never be released because there is a charge sheet filed against him or a complaint filed against him. So in special statutes, wherever such a twin condition is there, there are a number of judgments which take care of this fact that the twin conditions do not mean seeking an acquittal at this stage. Although in unlawful activities and in the other cases, Supreme Court also has felt that it is these are serious offences of unlawful activities or of terrorist activities or terror funding. Wherever such kind of situations come, it's basically those facts which weigh in the mind of the court. Makoka, for an example. But wherever these are not the kind of situations where we are dealing with, then the general law is applicable. And general law, the tests are the triple test, as they say, of the person, whether he is likely to flee from justice, is he a flight risk, his availability at the time of trial, the fact that is he likely to tamper or hamper the investigation. These are the basic, the paramount considerations the courts have held to be. So cases of the customs, excise, they are now these days not so common. And in those cases, the bail is not, the conditions are not so stringent. Although, I add a rider here, with the new GST law and the GST evasions as they came up, there was a judgment passed by the Supreme Court where the Supreme Court actually wanted to make it a slightly stiffer. And they said that in GST, a man can be arrested even without an FIR being registered. In such kind of economic offences, those observations become very dangerous, because they say that in such kind of economic offences, anticipatory bail should not be, but those are random observations. even after these observations, high courts all across have granted bail under the GST law also. Yes, to ensure that the person is not a flight risk or does not jump the bail, there are conditions which may be imposed, but those are as per the general provisions of law. Similarly, in NDPS, Makoka, UA, wherever the conditions are there, the twin conditions, the courts have now agreed to this principle that the case-to-case basis one should see. Prosecutor will be allowed to oppose the bail. However, you will be allowed to show to the court that there is a prima facie case in your favor. Yes, this is slightly uphill task, but this is one hurdle which is not as it appears in the law books. It's not as stringent because the courts have diluted it. Supreme Court time and again has said, and our own High Court as well as the other high courts across the country have said, that this test will be of a prima facie level only. Keeping that in mind, now coming back to PMLA, which an SFIO that we see every day these days in the newspapers also, the Enforcement Directorate and the SFIO cases against the company corporate violators and the so-called economic violators. There was a dispute and there has been a debate about the amendment in the PMLA statute which has come. That amendment came after Nikesh Tarachan Shah's judgment, where section 45 was sought to be restored by an amendment. For whatever the wisdom that the legislature had, they have not reincorporated, in my humble opinion, the twin conditions. So I reassure and reiterate my point that the twin conditions in PMLA do not exist today. Reason is supported by the judgment of our own High Court in Upender Rai's case, where our High Court has analyzed just the Nikesh Tarachan Shah's judgment, the amendment, and the situation now. And on that analysis, they said that these twin conditions do not exist as of now because the amendment does not restore the twin condition. There has also been a debate whether in these cases an interim bail can be granted. In NDPS cases also, and interim bails have been granted. Again, the interim bail considerations will remain the same. Only the duration of the bail changes. It's not that for interim bail, one needs to carve out a separate niche. It's not so. You have to reaffirm your case in the same manner in the special statute as a regular bail, but additionally, you have to establish your grounds which you are seeking bail on. It is those grounds which will have a value as far as the interim bail grant or rejection is concerned. There's nothing alien to it. It is the same parameters, only the considerations change. For interim bail, there is generally a more compassionate view which is taken because it is for a limited duration and it is on exigencies which arise in one's social and the social life and his difficulties which he faces all across in his life. And he might just find that he needs to, do an act, or he has to come out for some social obligation or for some obligation in the sense of financial obligations or some difficulty in the family. So interim bails are on that basis. And the provisions of anticipatory bail, unless prohibited by the statute, will also remain the same. Our judgments of Satlingappa Matre, Gurbakh Singh Sibia remain the same. The yardsticks for grant or rejection will remain the same. Only one, as a lawyer, has to see whether in the particular special statute a prohibition is imposed or some kind of stringency has been imposed. Then you have to encounter that. Do not forget, when seeking bail, that your emphasis all across is on your prima facie case as an under trial prisoner. If it's an under trial prisoner, the presumption of innocence, unless that presumption of innocence has been taken away by the special statute itself, the presumption of innocence will remain. Because there are certain statutes where mens rea has been burdened on you by way of a presumption. Assuming the case to be even bailable, the presumption of innocence or presumption of mens rea, if it finds mention in the special statute, then the special statute prevails. So please, once you are going through any special statute, you have to ensure your liberty. For ensuring the liberty, you have to see what is the class of offenses. If it's a class which is considered serious and the offenses are considered heinous, it is generally gauged by the severity of the sentence. A sentence up to 7 years even gets the benefit of Arnesh Kumar's judgment. Arnesh Kumar's judgment, where Supreme Court, in terms of while interpreting section 41A of the CRPC, had categorically said that these guidelines were for all cases and all offenses which are punishable up to 7 years, and was not limited to only IPC. But post Arnesh Kumar, now Prevention of Corruption Act amendment has taken the punishability to 10 years. So that takes it beyond it. Corruption Act, one has to encounter the offense of the prevention of corruption and the psyche. The judicial psyche today and the trial by media somehow paints a picture of corruption cases as really, really bad cases, and therefore the bail should be denied. However, it's not so. One should not lose heart, even if it's a case of Prevention of Corruption Act or Prevention of Money Laundering Act. You need to focus on the basic law. After you have encapsulated your case in terms of the basic general law, all that you need to do is thereafter factor in whether there is any particular thing that I have to meet. Do I have to meet the allegation of presumption of culpability against me? Then if you have to meet a prima facie case, then I have to show that I have an arguable case. The prima facie, there is an improbability of the version. I am not seeking an acquittal. You have to emphasize on those points. So ultimately, in a nutshell, you have to understand whether any rigors have been imposed, whether a condition specific as far as your case is concerned has been imposed in the statute. And if not so, then the general law prevails, and general law on bails also prevails. For the purposes of the separate statutes, one can understand and you can compare the different provisions. You will find the NDPS Act, section 37, the section 45 of PMLA, section 212 of Companies Act, section 43, if I mistake not, of the Unlawful Activities Act, section 21 of MOCOCA. All these statutes provide for these rigors. However, each of these statutes, the Supreme Court has considered these rigors, and over again, in not just one but several cases, gone to the extent of granting protection, granting bails, granting the liberty to the people who have been accused of those offences. The one such case which comes to my mind is the state of Kerala versus Ranif, where Justice Karju goes to the extent of saying that if there is a prolonged trial, can you deny the person his liberty merely because there is a charge, simpliciter adding a tagline of the unlawful activities, he should be denied for eternity. And while considering the section 43, he directed the grant of bail and said that this reasonable grounds has to be seen on a prima facie basis. So the satisfaction which you have to provide to the judge is a prima facie satisfaction only, because this is a negative burden. We have to discharge this burden on at the stage where the normal course would have been the prosecution discharging the burden of my culpability. Here, I have to discharge the burden that I am not guilty. So the Supreme Court says it is only a prima facie case. You would find in special statutes, there are umpteen number of special statutes. Somehow we get embroiled only in these popular ones, or probably ones which keep coming in the newspapers and media. They keep reporting in the media, or they have an impact in our society as such. So somehow we get a tendency of only looking at these statutes. But you'd find there are several statutes where these offenses, these rigors have not been placed. There are several statutes which have not categorically dealt with. They simply say that the offense under that statute will be deemed to be cognizable and non-bailable. Beyond that, they do not go. So in those cases, you have to resort to your chapter 33 of CRPC, where 436, if it is a case defined as non-bailable, then you go to 437. If it's a case of being non-cognizable and a complaint is filed, then you have to resort to your court on its own motion. Delhi High Court has dealt with in a judgment of a division bench as recent as about 2 years back. Justice Vipin Sanghi in a division bench has reiterated the same view, that if the prosecuting agency has not arrested the person and the offense is only 7 years or so, then release the person on bail. The court should not become like the prosecutors and the investigators. There is no purpose of taking the person in your own custody. There are cases where in Wildlife Act, in the other prosecutions of Companies Act, the cases where Minimum Wages Act, Payment of Wages Act, which are basically summons trial cases, the punishment is not much. So please first see if the statute deals with what is the gravity of the sentence, what's the severity of the sentence. If the statute does not deal with it on bails, then you come to the classification in the Schedule 2 of the CRPC, Schedule 1, Classification 2, which categorically talks of offenses up to 3 years are bailable, 3 to 7 years are non-bailable, 7 or upwards are non-bailable and sessions trial. So one has to see first what is the sentence. Merely because it's a special law does not mean that the general law is ousted. No. The general provisions of the procedure may not be ousted. Simply by saying that a rigor is added does not mean that the other tests are to be forgotten. No. You will still have to emphasize as counsels that this is a case of the person not being a flight risk. This is a case of prima facie being innocent. You have to show that the accusations are not prima facie made out. There are materials in your support. All that you will need to address when you have to deal with bails in special statutes. The criminal, as they call, are not to be denied their liberty simply because there's a tag of special law. The liberty is as precious to any person as it is to an accused as well, and therefore the liberty has to be protected, and bails as a general rule have to be granted. That's the general rule. Bails have to be granted and denial is an exception. And this has been the avowed principle right from 1978, where Justice Krishna Iyer in his judgment said that bail is a rule, denial is an exception. The same thing holds good today as well, and was reaffirmed in the recent judgments of Sanjay Chandra and Dataram Singh, where though it was not cases of special law, but Sanjay Chandra was a case of special law. It was a case of Prevention of Corruption Act. But yet the Supreme Court granted bail. The man had been inside. So one has to bear in mind, what's the charge against me? Does the special law oust me in any manner? Or does it simply add a rigor against me? If it does add, then how do I encounter it? The general test will be followed. The under trial prisoner must be afforded all his reasonable opportunities to protect himself. In this manner, you will find that you will be able to address all the issues. Now, something which I must tell my younger friends, while drafting your bail applications, even in special law, I find somehow we go amiss in reaffirming the principles which actually govern bails. You have to re-emphasize the fact that you are not a flight risk. In your bail application, in your pleadings, you must create a situation, a semblance of your defense. You may not disclose your entire defense, but there must be a semblance of that defense. Otherwise, it looks like a sham and a flimsy bail application. Somehow, there is a misconception that the bail applications can be cursory. They can be just very sketchy. You just need to write 2 pages. But then, when you are dealing with special laws, you must ensure that you plead and emphatically say that your case is a case of acquittal. Your case is of you being able to and being confident of vindicating your innocence, and you will be able to plead before the court concerned whenever that situation arises, to emphasize the fact that you are available for trial, to emphasize the fact that you are not running away from facing the trial, and you are confident of seeking innocence and proving your innocence before the court of law. Unfortunately, we get bogged down. Unfortunately, we hold the special statutes as if something they've somehow come from an alien world, and then they put pressure on you. There is no need to take any such pressures on special statutes. All that you need to do is be careful of the rigors, the embargoes, the conditions, and just in your pleading for your memory and for emphasizing before the court, so that you could go back to the court and say that you have categorically said it in your pleadings as well. And the fact that it has a recall value, and you are able to take that point, re-emphasize those points. So whether it be NDPS, yes, you might find a problem in cases where there's commercial quantity, but then you have several other provisions. If there is a violation of those principles under section 50, 42, 57, then you can seek bail. You have a right to seek bail because your investigation is not proper. You can always say there is a taint in the investigation. There is basically the law has not been fair to you. Be it PMLA, you can always say that section 3, where the proceeds of crime are not made out. You have to also show in PMLA that whether it's a scheduled offense or not, because generally, simpliciter, a case is picked up and they pleaded that it's a scheduled offense. But whether am I guilty of that scheduled offense or not, or is there the scheduled offense there against me or not, one has to see. In cases of Companies Act, we somehow get swayed today we really forget that if it is prior to the date of the amendment, then the rigors may not apply to you, because Companies Act cases have been coming up after a long period of gap when the investigating agency had been investigating the affairs of the companies. So please see whether you are past the amendment date or before the amendment date, your act which is alleged, because if it is past the amendment date, then only rigors apply to you. So the retrospectivity of those rigors will also have to be seen. There cannot be any retrospectivity of rigors. Those are the settled judgments till now. In unlawful activities, you will have to see whether there is terror funding or not, or it's a simpliciter case which is being brought under the terrorist acts. Similarly, Makoka, you will have to see whether there's a single case or a single charge sheet. So, in all, because these are vast subjects, I also cannot go through all of them to tell you each of these examples. I can only say that grave and heinous offences which are covered under the special legislations, there are specific stringent provisions. By and large, all other statutes ordinarily follow the general law. So with these things, I conclude my this webinar for the purposes of trying to share with you my understanding of this subject. If there is any questions, then I feel that Gurpreet, if you are there, then
yes,
if there are any questions, then I am ready to answer.
Yes, sir. There are actually, they have many questions which have come up.
I hope I have made myself clear.
Yes, yes. Sir, the question is on the screen itself, and I'll be reading them to you as well. The attitude of the trial courts, including session court, has been to refuse bail in serious offences. The courts are often not inclined to grant bails in such offences. Please comment.
Ayush, this is a problem which we all face as defense counsels. I don't say it's an attitude of the trial court, but it's a general attitude today, as I said, that there is a psyche which has been created, that these cases are today highlighted in media, therefore they become serious, and the courts are slightly reluctant. But once again, I say, it's not that the courts are not inclined to grant bail. You have to bring your case under in the four corners of trying to meet those special statutes also. See, sessions courts by and large are dealing with heinous offenses only. They don't deal with your petty offenses. Those are generally before the magistrates. So when you are dealing with the sessions court for your bails, you have to take it that you have this issue against you, that you have to cross this hurdle of showing a prima facie case in your favor. Especially so in special statutes, wherever there are rigors. If there are no rigors, and sessions is not the final court, Ayush, you have the high court. And what better for a lawyer? You get two opportunities to argue. So don't get disheartened.
So this is the next question. Under NDPS Act, if a person has been declared proclaimed offender and his property has been seized under the relevant provisions of the Act, if the person who has been declared PO acquires some more property by virtue of civil litigation or by way of will after declaration of being a proclaimed offender, whether this property can be seized by the NDPS court by making an alteration in the order of seizure or not.
Sohail, can I say something on the aside? I think you are trying to seek an opinion from me on this webinar for bails. You can contact me, I'll answer it. But then one has to see the time period. See, declaration of a proclaimed offender does not bar you from everything. Once you have been declared a proclaimed offender and you have then thereafter submitted to the court, proclamation of a person as a PO is only for the purposes of compelling his appearance. If you see the chapter is to compel appearance, which starts from 62 till 84, section 84. So don't get bogged down by the fact of proclaimed offender. You will need to go through the facts of the case. The PIT NDPS Act governs this portion of the person's property being seized. PIT NDPS itself also provides for the remedies which are available. We can chat on this anytime that you want. But this will be a longish answer. I wouldn't be able to answer it here, not especially when I'm dealing only with bails here.
Yes, sir. So this is the next question. How should an advocate tackle the wide discretion of the judge while arguing for bail, especially in cases of serious nature as POCSO, PMLA, rape, murder, etc.?
Mudra, may I just say one thing? An advocate has to tackle the facts of his case, basically row it in the river of the judge's discretion and row it across the stream to your success. Whether it is a case of bail for under POCSO or PMLA, rape, murder, whatever it is. See the discretion, and when you are talking of a judge and you are talking such serious offences, you are talking of a sessions court, and presuming that, see, the power under 439 is very, very wide. These, barring the inhibitions which a judge may have in his own mind, there are no shackles which are put in these cases with the court which are different from a sessions to a high court. There are none whatsoever. Dealing with any of these offences, you must marshal your facts. You must be very sure of your facts. Test it on the yardsticks provided as the ingredients of the offense. Once you have tested it on the ingredients of the offense and you find that you have a good case, then my request to all, especially the younger lot, which is the future bar of this country, don't get disheartened. Don't rush yourself in. You should be calm, composed, and confident. Please keep these 3 C's in mind and always argue with conviction. You must believe in what you are arguing. If you are shaky yourself, you will never be able to put your point across and convince the judge. So keep that in mind when you are dealing with any judge, and always never hurt his ego, never hurt his sentiments, but always implore him to use his discretion in your favor. That is why I'm saying you should be calm, composed, and confident, so that he also starts getting convinced. That's the 4th C.
Yes, sir. So this is the next question. A person after appearance is declared a PO in a 138 negotiable instruments matter. 174A FIR was not registered. Made it clear that the accused would be sent behind bars. 438 CRBC moved. Sessions Court declined, saying, I think there is a 2-part, that the 438 CRBC is not maintainable in bailable offence. Is that a correct view because of apprehension of arrest is there? What's the remedy then for the accused?
Roshan ji, I think you have missed out. 438 starts by the words, whoever is accused in a non-bailable offence. So in a 138, 438 will not apply, first thing. To that, the judge is right. Remedy is either go in a revision or in a 482. Because if you have been declared a PO after your appearance, then it is not a declaration of a PO as in compelling your appearance for the first time, to which there are judgments of the High Court also, which say that if you have not appeared and even if you are a PO, you go and appear, you will be granted bail because it's a bailable offence. But if it's a bail which has been cancelled and you've been declared a PO, it is subject basically in terms of section 87 of the CRPC. So in terms of section 87, if an order has been passed of basically recalling your bail bonds and cancelling your bail, then you have to challenge it by way of either a revision or a 482. 438 is not the proper remedy, in my humble opinion. I don't know if there is any law to the contrary.
I think there is one more question, sir. Why Section 67 of the NDPS Act is not equated with the Section 161 of CRPC? Does the statement, confessional statement given by the accused or the person who has been summoned under Section 67 of the is admissible? Is
I
a
responded. Gurpreet. Sohail, I feel, I'm sure you have some NDPS with you in your hands, and all your questions are on NDPS Act and all questions beyond bail. तुम्हारे बंदे को शायद bail तो मिली नहीं है अभी तक. So let me just answer it. Section 67 of NDPS Act is because the NDPS Act was framed also in terms of the the Universal Conventions to which India was a signatory, where the drugs were considered a global problem, a global issue, and therefore in the as a the international charter and international agreement, India was also bound to frame this law. And Section 67, because the offence was considered serious, heinous, and hitting at the what would one would say the future generations of the country, the Section 67 allowed the admissibility of the statements and was not equated with Section 161. Now, the validity of Section 67 has already been upheld by the Supreme Court in a constitution bench. Secondly, Section 67 is akin, for your purposes, I may say, to 108 of Customs Act, old Section 40 of FERA, and Section 14, if I mistake not, of Excise Act, where the statements given to those investigating agencies were held admissible. But in such cases, always, there are safeguards which have been put, and therefore Section 67 statement, after Noor Agha's judgment, if you read, it's not that simpliciter Section 67 statement would be considered as admissible and taken against you. You have a chance to retract. You have a valid opportunity, and an opportunity is available to you at the time of your remands to retract from this. Baki isme detail mein whenever you want, you can always come and talk to me. Section 24, 25, 26 of the Evidence Act, as far as confessions to people, the police is concerned, are not applicable to this extent here because the special law, when legislated, incorporated this portion. And therefore, and another thing was that NDPS cases, there was another issue that Narcotics Control Bureau was created to basically take care of the investigating agencies, the investigating part. And 24, 25, 26 could not apply to them because they were not deemed to be police officers. ये बहुत लंबा चैप्टर है, इस पे अकेले पे मेरे को पूरा एक वेबिनार लग जाएगा, कोई इस पे मत है. You are most welcome to contact me, Sohail. अपने इस केस को संभाल के रखो, we can discuss it on phone. Anything else, Gurpreet?
Sir, I think this is one last question. Sir, can you please elaborate on the merits of the case which need not be addressed in bail proceedings?
Rishabh, this is a very actually an issue which you as a counsel over years will develop, and that is you must know how much to speak and how much to hold back. The merits of the case which need to be addressed, in my humble view, is all that which nobody can controvert. If you can say something which cannot be controverted as an under trial at that stage, and it has not reached the stage of your testing in the evidence, only that much you must speak. If you have any fear that something you disclose as a defense for getting your bail may get covered up by the prosecuting agencies, then you are well within your wisdom to hold it back. But I still say merits of the case are always the positive part. It is the demerits of your case which you need to hold back. And what need not be addressed in the bail proceedings are something which you feel might come up against you or might be used against you or might prejudice the court. See, ultimately you are seeking a discretionary relief. So when you are seeking a discretionary relief, you have to come clean but keep the picture always within the four corners of what is positive for you. I hope that answers you. If there is any query, you can always contact me. Yes, Gurpreet, anything else?
Sir, I don't think so. There are any more questions. This was the final question only.
Chalo.
Hopefully, I have. I don't think so. There's nothing displayed also. So, so with this, I would like to thank you for such a knowledgeable, insightful, and a candid session. I hope the viewers are able to enrich themselves with such a session. And on behalf of Dufla, I once again thank you for sparing your valuable time and talking about a topic of such importance and ever so contemporary issues. I thank you once again, sir, for the session. I thank all the
Thank you.
viewers.
Thank you, Gurpreet, and thank you everyone for listening. I hope it helps you out somewhere in some way or the other. I am always there in the High Court. I can only say that for the younger members of my fraternity, that whenever you need help, it's our bounden duty as seniors to help you out, guide you, so that you strengthen this institution in future. Thank you very much, and thanks Gurpreet, Shubham, and Amit for letting me this opportunity to come and speak on this subject. Thank you very much. Thanks.